Thank you, Professor George Nyabuga, and also thank you, the Dean, Nancy Booker, who is hosting us for the second time. The first one, as the majority of you know, we got together in May, just 2 months ago, kind of saying how important it is to work together, have media experts, human rights experts together in a room. Without media and truthful and responsible reporting about these issues, we are not getting very far. So the importance of media is important in all what also Wayamo does. And by the way, I'm also a former journalist. My voice is a little strange. Anyway, let me start with thanking the Dutch and German foreign ministries who have generously supported this event, and also the workshop which will follow this event, the next 2 days, on monitoring and documentation of human rights violations in Sudan. We will have also in the training roughly 25 human rights monitors, activists, and journalists together from Sudanese diaspora. And I want to really make the point here, the majority of the people in the room have left Sudan after 15th of April under absolutely dramatic circumstances. AGJA, who was giving us a message from Darfur the last time when we were here in May, there's Guja. He arrived last night from Darfur. You know, so you can, yes, please. And I just, you know, he stands for many of you who recently arrived under very dramatic circumstances. And I, you know, being in Berlin, comfortable in our office, I just want to acknowledge that I'm aware that you have been going through very tough times. So in this respect, I also want to say what we're doing here is not merely academic. It really matters. It is something which matters to you and which will be very helpful potentially for future accountability mechanisms. 17th of July, let's call us a happy International Justice Day. So today is the anniversary, 25 years of the adoption of the Rome Statute, which was adopted on 17th of July, 1998. What's wrong? So it's 25 years ago. So we also, with this, want to mark the importance of fighting impunity and bringing justice for the victims of war crimes, crimes against humanity, genocide, and the crime of aggression. But more importantly, on the one hand side, yes, happy Justice Day. But what we want to do here is really put the spotlight on Sudan. Thank you, that's so nice. We want to direct our attention to what's happening in Sudan right now, where since the 15th of April, there are atrocities happening, and some people just continue as if nothing is happening. We want to really put the spotlight on Sudan on the International Justice Day, where since 15th of April, we are seeing hostilities happening. I also want to extend a special welcome to Radhouane Nouicer. I think I pronounced it not correctly. He's the UN independent expert on the situation of human rights in Sudan. He arrived last night, very late, coming from Europe. I really appreciate all what you did to be with us today. I also want to welcome again Betty Murungi, my sister, my Kenyan sister, I would say one of the most known transitional justice experts in Kenya. She has many titles, many things. I will not go into detail because I think you know her. If you don't know her, Google her. It's amazing. I also want to welcome Philip Ambach from the International Criminal Court, experts from Mnemonic and GISA who are here, Kulut Kai, who's here. The last time I saw Kulut was in Khartoum in September of last year, where she moderated one of our panels in Khartoum. Unfortunately, we cannot be in Khartoum right now. And I also would like to welcome Abdullahi Hassan from Kenya. There he is, who will be also one of the speakers. So all of them, thank you for coming. This will be the speakers of the day. Nevertheless, we don't want the long speeches. You know me, I always, the rule is 10 to 15 minutes. And after that, Q&A, interactivity is important. It is important to get to know each other, especially in a crowd like this of Sudanese diaspora and Kenyan colleagues. Get to know each other, use the coffee breaks, intermingling with people. That's really what is very important here, and learn from each other. During the day today, we will hear about the dramatic human rights situation in Sudan. We will discuss possible transitional justice mechanisms for Sudan in the region. We will discuss the question of how to classify serious human rights violations being committed in Sudan right now. Are these international crimes? When? Where's the threshold? What do I have to fulfill? And we will discuss the role of digital open source information, the role this can play in potential future accountability mechanisms. So that's also a little bit our desperate attempt to do something meaningful in times of war. And we think that there are tools which enable us to be proactive, even in times of war. And that is doing trainings like this, but you are practitioners. It comes then to documenting and collecting evidence for future accountability mechanisms. That's the little contribution Wayamo hopes to do in the next month, hopefully years, to strengthen the capacity to do that, so that what we collect and hopefully one day put together in a central repository can be used one day for accountability mechanisms. And with these words, I want to finish and wish us a very creative, interesting, and interactive day. And without further ado, I now would like to immediately invite our first two speakers. As I said, we will start with Radhouane Nouicer. Nouicer. Okay. As I said, the UN independent expert on the situation of human rights in Sudan. The floor is yours.
Thank you, Bettina. Good morning, everybody. Thank you, Wayamo, for giving me the opportunity to be with you today and part of this timely and important symposium where you decided to place Sudan at the very center. Thank you all for attending. My name is Radhouane Nouicer. I am from Tunisia. I was appointed in late 2022 by the UN High Commissioner for Human Rights as his designated expert on the situation of human rights in Sudan. Initially, mandate consisted in monitoring the human rights situation since the coup of 25 October 2021 until the placing of a civilian government. With the outbreak of the hostilities on 15 April between the two armies, the Human Rights Council, during its meeting of 11 May, has decided to expand the mandate to cover the violations and abuses that are taking place during the ongoing conflict. Let me say from the outset that the miserable human rights conditions in Sudan are not the result of the current conflict. The history of Sudan, unfortunately, since its independence in 1956 has been tarnished by a great deal of internal conflicts. There have been 36 military coups or attempts, military coups in Sudan. Only 6 have succeeded, bringing Mr. Aboud, Mr. Noumeiri, Mr. Siwar Dab, Mr. Omar al-Bashir for quite a long time, and then Mr. Burhan twice in 2019 and in 2021. This very tense period in Sudan's history has culminated in a number of major issues like the fight of South Sudan for more prerogatives and more autonomy, and then the war in Darfur in 2003, the military coup of 2021, and more recently, the inter-military conflict in Sudan, reminding all of you that Sudan has been on the agenda of the Human Rights Council for 3 decades without interruption. This is, unfortunately, the cumulative result of decades of ill management, of corruption, of lack of accountability and justice. The chronic divide, this is another important reality in Sudan, divide between civilian political leaders and civilian political parties, the presence of a countless number of paramilitary entities affiliated or not to political groups, and indeed the poor economic performance of the country. I visited Sudan in March 2003. And I met with a large number of civil society representatives from all horizons. 3 major points were repeatedly raised nearly in almost in all meetings. First, the climate of impunity and the lack of accountability in Sudan, which has been prevailing for decades, the lack of trust of the people of Sudan in the state institutions, particularly security and justice, and 3, the need for a more effective accountability in the country. To the extent that most of the speakers in these meetings have requested to place Sudan under Chapter 7 of the Charter of the United Nations, and to deploy an international force to provide protection to civilian Sudanese. Up to the night of 15 April, we thought, all of us, naively perhaps, that progress has been made. There has been this famous political framework agreement adopted on 5 December 2022, widely participative consultations on the issue that were left outstanding during the adoption of the framework agreement. And these consultations sincerely have produced very good action plans with a strong language on human rights and accountability. The only issue which has not led to any agreement is the reform of the security and military sector. From the outset, the leaders of the 2 entities, Mr. Burhan and Mr. Hemeti, have always expressed diverging views on this issue, particularly on the issue of the integration of the RSF into the National Army and the timeline for establishing a unified military command and structure in the country. Everybody, all influential entities, the UN, the African Union, the AGJA, the UK, the United States, Great Britain, and many others have conducted an intense engagement to mediate between the two military bodies until the night of 15 April. On 15 April, malheureusement, we all wake up to see that the two sides, Mr. Burhan and Mr. Amati, have decided to settle their unresolved conflict on the battlefield rather than at the negotiating table. Today, more than 3 months have passed since the outbreak of the conflict, and despite the repeated declarations of ceasefires on both sides, there has been no day without violence, without victims, without destruction, and neither side has been able to declare military victory. Believe me, colleagues, I have dealt with many difficult situations during my career. I have worked in Syria, in Yemen, in Iraq. I have witnessed many violations, and I have seen thousands of people who have been uprooted, families separated by forced internal and external displacement. What is taking place in Sudan is very, very special. It goes beyond, very much beyond, what I have seen in terms of violence, atrocity, destruction, and total disregard to human beings. The conflict is taking place, as we all know, mostly in heavily populated urban areas, with civilians taken hostage. The figures provided by the UN and many other entities on the number of casualties do not capture really the terrible stories of thousands of Sudanese men and women who abandoned their homes and went into internal and external displacement. Neither do these figures reflect the suffering of millions of Sudanese who could not leave their homes for security reasons and remain stranded there with no food, no water, no medicines, no communication means, and certainly with no access to humanitarian assistance. The acts of violence are widespread, to be frank with you. Homes, shops, places of worship, water, electricity installations, embassies, humanitarian warehouses, all have been looted, destroyed, burned, or damaged. A large number of bodies were buried without identification. The health sector is collapsing, as we all know. The report on sexual violence against women and girls are appalling. Children are facing serious protection problems and continue to be vulnerable to recruitment, sexual violence, abduction, in addition to the interruption of their schooling. Even the cultural heritage of Sudan has not been spared, like the attack on the old souk, old market of Omdurman, and on the Khartoum Museum. Criminality is compounded by the release of thousands of prisoners and the increasing spread of small weapons and the total absence of state agents in the streets to enforce law and order. The report of Human Rights Watch of last week, I hope you have read it, is very painful. It states that RSF and allied Arab militia summarily executed at least 28 Masalit, African Sudanese. On 28 May, injured dozens of civilians in West Darfur in the village of Mystery, destroyed and burned the whole village, looted the hospital and the schools, forcing thousands of people to flee to Chad. Such accounts echo the horror and devastation and despair in Darfur 20 years ago. My team and myself, our mandate is to document and report on major violations and abuses. We rely on reports received from colleagues on the ground. We still have many colleagues inside Sudan working in safe areas, meeting with internally displaced people and reporting on the variety of cases they interview. We also rely on teams that were placed at the border areas with Egypt, with Chad, with Ethiopia in particular, and who meet with Sudanese seeking asylum inside this country and report to us. We also cooperate with UNITABS, which has a human rights unit. We are in very close contact with UNHCR offices in the countries surrounding Sudan, where they receive thousands of asylum seekers and interview them for protection purposes. We also organize a weekly meeting with NGOs, some of whom are Sudanese NGOs based inside Sudan or outside Sudan. Some of them are represented in this forum, and they provide us with their testimonies and reports. Bettina has insisted on the respect of time, so I have to skip a few things. I will not, dear colleagues, take the risks of to enter the domain of her Justice Betty Murungi, advocate of the High Court of Kenya, and the other lawyers who will speak later, in addressing the legal aspects of this situation and the potential role that the International Court of Justice, International Criminal Court, can play in addressing the violations at stake. I will just remind that even war has its principles and its rules, particularly the principle of distinction, the principle of proportionality, and the principle of precaution. Clearly, none of these principles has been observed in the current conflict in Sudan. Attacks on civilian subjects, people, or combat, damages inflicted to residential buildings, schools, hospitals, as I said, museum, occupation of and looting of everything. This can only entrench the feeling or the sense of impunity that is prevailing among the Sudanese population. It is the duty, in my view, of the international community that there is justice. The loss of a family member, the loss of a friend, the disruption of a child education, the loss of a house, of private properties, the displacement of one from her or his house, the feeling of a raped woman or girl. All these horrendous acts require justice. This is not politics. This is simply humanity. The International Criminal Court, which is also called the Rome Statute, is an instrument of international justice and deterrent against future atrocities. It has jurisdiction over serious crimes such as genocide, crimes against humanity, and war crimes. There are three different mechanisms for the exercise of the ICC, the International Criminal Court jurisdiction: referral by state party, meaning the state submits itself to the jurisdiction of the court; two, the investigation proprio motu of the ICC prosecutor; or referral by the UN Security Council acting under Chapter 7 of the UN Charter. Sudan signed the ICC statute in 2000, but has not ratified it. Part A, there is no parliament. Okay. It is therefore not party to the Rome Statute. However, the Security Council, in its resolution 1593 of March 2005, decided to refer the situation in Darfur since 2002 to the prosecutor of the International Criminal Court and requires the government of Sudan to fully cooperate with the prosecution. As a UN member state, Sudan is legally obliged to cooperate with the court. Therefore, the ICC has jurisdiction over crimes listed in the ICC statute committed on the territory of Darfur. We may need another decision to cover the whole Sudan or other areas of Sudan. And that is from 1 July 2002 onwards. There is some light in the end of the tunnel. In his presentation to the UN Security Council 4 days ago, on 13th July, Mr. Karim Khan, the ICC prosecutor, has stated the following, I quote, "We are, by any analysis, not on the precipice of a human catastrophe, but we are in the very midst. It is now occurring." He added, "We have already started investigating." This is what I wanted to share with you, dear colleagues. In conclusion, I would like to again thank Wayamo for this opportunity to express my admiration, really, for the resilience and bravery demonstrated by Sudanese people. I remain confident that with their huge sacrifices over decades, the Sudanese will not accept any new dictatorship, and that accountability will come sooner or later. Shukran. Thank you.
Thank you very much, Radhouane. This was very interesting and a very strong ending. I would like to invite Betty Murungi now to come and talk to us. Thank you.
Thank you, Bettina.
Good morning, friends and colleagues. Bettina, you shouldn't have spoken about the anniversary of the Rome Statute, because it just reminded me that I was in that room in Rome. So that just, makes you all know how old I am.
You said it.
Yes. I was in the room. And so I begin there in 1998. The world was very hopeful. We thought that now that we had concluded this treaty establishing a permanent international criminal court, that we were going to have better prospects for justice, and especially an end to impunity for the most serious crimes known to humanity. And so, since 1998, we saw the ICC, the International Criminal Court, come into effect. Some of the first cases involved Sudan in 2005. The UN Security Council referred the situation in Darfur to the ICC. 2009, we saw indictments issued against the president of Sudan then, Omar Hassan al-Bashir, and others for the crimes that were committed in the western part of Darfur between 2003 and 2009. 3 years later, unlike what we see happening in the case of Ukraine, for example, a pre-trial chamber was assigned to the Sudan case. Arrest warrants were issued. None were executed. In 2010, we saw Bashir actually come to Kenya to help us, to celebrate with us as we were celebrating our new constitution. Thereafter, the International Commission of Jurists, the Kenyan chapter, went to court, obtained warrants of arrest against al-Bashir twice. He was not arrested, of course. Who was going to execute the arrest warrants? And many other countries. He continued to travel the world, and I'm glad to see, Andrew, you're here. You remember those battles of going to court to obtain orders. The Kenyan courts were very good, said, in fact, he's not supposed to come here. We are state parties to the Rome Statute and so on. But he continued to come with impunity, and not just him, many other people that had been indicted alongside him. And then, the years have passed. We saw some trials begin at the ICC, which have not been concluded on the situation in Darfur. And we see the Karim Khan, who is now the prosecutor of the ICC, speaking, as Radhouane has quoted to us, just 4 days ago in the UN Security Council when he was briefing them on the situation in Darfur, and talking about the dark cloud that is hanging over Darfur, and saying that he is opening an investigation into the new spate of atrocities, atrocity crimes that have been committed. Of course, atrocity crimes have continued to be committed in Darfur, not just since April 15th, but over a long period of time. So it is good. I mean, I think we can only say it's perfect that he's begun that investigation. And so Bettina asked me to reflect a little bit for us today about the principle of universal jurisdiction and what the state parties to the African Union and the state parties to the Rome Statute and the neighboring states to Sudan can do to help address the question of impunity. We know, of course, that in Kenya is quite critical to peace-building efforts in the region. We also know that a lot of the people that commit these atrocities in the neighborhood somehow end up in Kenya quite a lot of the time.
If they don't end up in Kenya, they end up in Uganda or Ethiopia or any of these other neighboring states. And so in reflecting on the exercise of universal jurisdiction by the neighboring states, what is it that we have to consider? First, not to just talk too much about the challenges, but just to speak to the issues that come into play when you consider universal jurisdiction. Number one is the jurisdictional restrictions which all these countries have in their laws around the exercise of universal jurisdiction. Number two is the opportunity for our states to exercise universal jurisdiction for these core crimes. The third is ability and willingness, which sometimes we refer to as political will, of domestic authorities or national authorities. But this is also, I think, now moderated by the attention span that international justice is having across the globe. It's like the attention span is so limited that it is now entirely focused on the situation in Ukraine, leaving very little attention to other situations. And we spoke about this at our last symposium, so I'll not belabor that point. The fourth and final issue for us to consider is the question of capacity, both technical and financial, for the exercise of universal jurisdiction. So after the Sudanese president was indicted by the International Criminal Court and arrest warrants were issued, the African Union got into sort of like a panic mode and created something known as the African Model National Law on Universal Jurisdiction over International Crimes. They quickly passed it through the African Union legal framework and adopted it in 2012. They were horrified that any international body or state exercising universal jurisdiction would have the temerity to arrest a sitting head of state or to consider initiating proceedings over a sitting head of state and what they called senior state officials. So you can interpret who senior state officials are. Those would be military leaders, would be civilian leaders, and political leaders. Now, this model law, the Africa Union model law, which has been adopted by many of our states, adopts a very narrow interpretation of universal jurisdiction. And the issues of concern which are addressed in that model legislation, which is important for us as we consider whether Kenya or Uganda or any other country is going to exercise jurisdiction, is the priority it places on the territorial state exercising its right to first bite of the cherry in terms of territorial and complementarity efforts. That they say that the states where the offenses are committed should be the first states to try any of the persons accused of committing atrocities. And the second issue, which is very important in the model legislation, is the immunity of sitting heads of state and state officials. Now, so that's that. So African Union accepts the universality principle, but draws the line at exercising it over sitting heads of state or senior officials. In fact, the model legislation goes ahead to reflect in the explanatory note that Africa did great because somehow the African Union was responsible for referring the Hissen Habre case to Senegal to try. Now, of all the African states, the only ones that have laws that permit them to exercise university jurisdiction is Senegal, Kenya, Mauritius, Uganda, and South Africa. And the practice in South Africa, I think, is the most advanced, and you can read about it. They've tried cases of torture that happened in Zimbabwe, but the perpetrators then had found their way into South Africa, and a couple of other cases. Kenya has actually exercised universal jurisdiction with respect to crimes of piracy, and our courts have been very progressive in terms of issuing arrest warrants against al-Bashir and a couple of other pirates and so on. I'm speaking about piracy because in our laws, in this African model legislation, it expanded the crimes that can be prosecuted under the universal jurisdiction to include piracy, slavery, and so on. Of course, our own law, which is the International Criminal Act, limits the exercise of jurisdiction, universal jurisdiction, to the 3 core crimes that are covered in the Rome Statute. And so what are the restrictions? And I'll speak to Kenya and Tanzania. The jurisdictional restrictions, I think, which become important for us is that in Kenya, the presence of the person being accused is strict. It's the principle of the presence of that person in our territory has to be complied with. That means the perpetrator must be present in Kenya before they can be prosecuted. Okay, in Uganda, it's also a requirement that for the prosecution to go ahead, the person must be present. Similarly, in South Africa, not so in Mauritius. However, it does not say that the law does not require the person to be present for the investigations to begin. So just to say that the work that you're all doing in terms of documenting violations is important for that stage of the investigation. There are many other sort of requirements that come into play, and I'll just speak to the Uganda ones and the Kenya ones because this is the most likely place where we would at least get civil society to begin to work with groups of victims and civil society groups in the Sudan to bring cases of universal jurisdiction to our courts. The 4 prerequisites to the exercise of universal jurisdiction for suspects who commit crimes outside of the territory of Uganda and Kenya is first the nationality or citizenship of the person against whom the crimes have been committed. And so for Uganda, they say if you go and commit a crime against a Ugandan in Sudan, in Darfur, for example, then they will exercise universal jurisdiction. The second is if that person who is committing the crime is employed by the Ugandan state or by the Kenyan state, or is part of the Ugandan military or part of the Kenyan military. That's also a prerequisite. Then they would exercise universal jurisdiction over that person if that person is the one that's accused of committing the offense. The third prerequisite is I've talked about that, if the victim is a citizen or a resident of Uganda or Kenya, or if the accused person has a nationality of Uganda or Kenya. And then the 4th prerequisite, which applies to both Kenya and Uganda, is if the person who is accused of committing the crime is resident in Uganda or Kenya. So you see, it's difficult. It creates all of these restrictions which are difficult to satisfy. An issue, I think, which we need to consider is around the issue of protection of the victims, survivors, witnesses, and organizations that are engaged in supporting the investigations, and how their investigations would be, and their reports would be protected and preserved to be used by other bodies like, for example, the ICC. Would this work that they're doing sabotage the work of, for example, the International Criminal Court or a future tribunal I know, and I hope we'll be hearing about the special tribunals that were set up to try perpetrators in the Darfur situation and how far that has gone. So why do we do this? I mean, we know that states such as Germany, which has cases, they are prosecuting a few of the Syrian cases. Switzerland, Spain is big on this universal jurisdiction, and of course Belgium. Why do they do this? It's because they want to obviously bring an end to impunity and make it difficult for perpetrators to find, comfort in the various places that they run to. We also do it. We also, sort of advocate for universal jurisdiction because of the limited jurisdiction of the ICC, and quite frankly, the failures or the delays that we have seen happen with the cases at the ICC. But most importantly is because victims deserve justice. It doesn't matter, whether it is the Belgians or the Kenyans or the Ugandans who are prosecuting, but it's important for victims to get justice eventually. It's been 20 years now since 2003, when the big conflict began or came to the attention of the international community in Darfur, and it's still going on. It's getting worse. It beats logic that we can be sitting here commemorating International Justice Day, and this has been going on for 20 years. So I think it's important that we recommit again to ending impunity for all of these core crimes. That continue to be committed. Now, 1 minute, yes. I just want to reflect a little bit about this prerequisite of presence. We know in Kenya, neighboring countries that have been at war for many, many years, the perpetrators not only find refuge in our country, but also end up doing a lot of business. They are very wealthy, they are very protected. They invest in our countries, in Uganda and in Kenya. There are reports out there about who these people are, where they live. They send their children to school in Kenya, so their life goes on. And so I think in terms of having these conversations, and here I'm talking to Wayamo, I know you have conversations with the Office of the Prosecutor, the ODPP, and other justice actors. I think this conversation needs to be expanded with them, because there is only so much civil society organizations can do. The courts are actually our allies because they have issued the correct judgments as pertains to universal jurisdiction. But the authorities that are responsible for initiating the investigations and actually bringing these people who are present in our territory to court lies with the Office of the Prosecutor and with the political authorities. So I think that is where we need to take the conversation and take it to them. In the meantime, also pray for us Kenyans, because, very soon we might be running away and coming to your own country to live there if we don't take matters in hand as matters stand right now. Thank you very much.
Thank you, Betty. And I have well listened to your last point, and I think it's an interesting idea, engaging more with the Kenyan prosecution on this point, and starting the discussion about what can be done with universal jurisdiction for Sudan. So I would like now to invite you for questions. I want to invite you to ask questions. Please always state your name and the organization you come from. No long statements, please, just one question. Otherwise, I will have to cut you. Please let me not do this. One question, introduce yourself, and you can ask our two experts questions. Please. Do we have the microphone? Oh, I'm sorry. Yeah. Right. So we are taking like 3, 4, whatever. Oops, sorry. Don't come there. So the first one here, please. And you can. How do we do this now? Can you speak in Arabic? How do we?
No, that's yeah.
Yeah, then you can say.
Thank you. Good morning, everyone. I'm Chalo Ali, a journalist. I'm a Sudanese from Nuba Mountains. My question goes to Radhouane, you are an expert. The crimes in Sudan, you mentioned about Darfur issue since 2003. As a UN expert, there has been crimes that has been committed since then, and people who are also indicted like Bashir, before even they were taken to ICC, another crimes is going on right now. Till when are you guys going to document these crimes, and when are these people are going to be prosecuted? You mentioned about not giving a statement, but I need to give an example of people like Sierra Leone. Okay. I am just wondering, when is the UN just keep on documenting crimes and crimes committed in many various countries? When are you going to prosecute these people? Because before one is done, another one is committed. Okay? Sierra Leone, Charles Taylor has been there. Where is he now? Dominic Nguen from LRA Uganda. Where is he? Okay? We have seen Bagbo Lauren from Cote d'Ivoire. These cases has been there, including even ICC cases in Kenya. These things are taken there. I don't know whether the UN have the powers to follow up these cases so that these people are prosecuted before one crime is committed again.
Thank you very much. Another question, please, or comment, brief comment. Please, go ahead.
السلام عليكم جميعا. أنا عواطف أحمد عواطف إسحاق، صحفية ومدافعة عن حقوق الإنسان. السؤال حقي إنه لما زرت السودان في مارس 2023 كانت فرص كبيرة إنك لأنه في انتهاكات كثيرة في الوقت ذاك، إنه كان في فرصة كبيرة في زيارتك إنك توجه بعض الحاجات وتعديلها يعني، أو تكون في قرارات صائبة تتخذ ضد المنتهكين. تاني حاجة الانتهاكات اللي تم توثيقها منذ العام 2003 ووضعت أمام القضاء أو أمام المحكمة الجنائية الدولية، ماذا حصل فيها، وخاصة الجانب اللي بيتعلق بحقوق الإنسان واللي بيكون مسؤولية المقرر العام لحقوق الإنسان أو الحاجات اللي بتوالي الانتهاكات اللي كانت.
Please, when we all talk, let's not forget that we have simultaneous translation. I know that they will love me for that. Please don't speak too fast, because it will be difficult for them to translate. Yes. 3, 4, 5, and then 6, and then, yeah, please remember. Oh, 7. I will not remember now. 1. Okay, please.
Okay, thank you. My name is Henry Karanja. I work for an organization called Conflict Dynamics International. 2 quick comments, questions. One is on the, if these cases are going to be referred to the ICC, is there a risk that then, because of the high threshold of evidence required to convict, is there a likelihood that then this is going to be taken as some sort of a mechanism to sanitize these individuals, so that you have gone through the ICC, no crimes have been committed, not enough evidence is available, and so these people then end up getting acquitted, and in the process they have become almost like sanitized. We have seen that happen with the Pierre Bemba in the DR Congo. In the case of who is now the Deputy Prime Minister, in the case of Kenya, no evidence was adduced, and now we had the former president and the current president who are both before the ICC. So is there that risk that the ICC could then become a mechanism for sanitizing people who have committed these very serious crimes? And then secondly, at what point may we invoke the doctrine of responsibility to protect? This is more specifically to the UN expert. Would it be applicable in a context such as Sudan? Thank you very much.
السلام عليكم. أنا آدم مهدي من دارفور 24. أنا عندي مسألتين موجهين للسيد الخبير المستغل في مسألة حقوق الإنسان في السودان. المسألة الأولى أنه دائما ننظر إلى التقارير أو التي تصدر من الخبير تميل ناحية الدبلوماسية أكثر من أن توجه المسؤوليات مباشرة تجاه الأطراف المنتهكة حقوق الإنسان في السودان. يعني نلاحظ ذلك كثير في مسألة دارفور ومسألة السودان عموما. يعني لا توجد أو يعني تستخدم اللغة الدبلوماسية أكثر من اللغة التوجيه المسؤوليات مباشرة. المسألة الثانية هي أنه الآن الانتهاكات من 15 أبريل إلى اليوم يعني بشكل فظيع وكبير جدا، والصحفيون ومدافعون حقوق الإنسان والناشطين الذين يستطيعون أن يرصدوا ويوثقوا حقوق الانتهاكات كثير منهم يواجهون مشاكل على الأرض، وكذلك أظن حتى الفرق أو العاملين لديكم يواجهون هذه المشكلة. كيف يعني بنظركم أنتم كيف يتم توثيق هذه الحالات في الظروف الحالية، في ظروف الحرب والقتل المستمر في السودان؟
السلام عليكم. أنا نون كشكوش، محامية، عضو التحالف الديمقراطي للمحامين، وعضو محامي الطوارئ، ومدافع عن حقوق الإنسان. طيب أنا بالنسبة يعني أسئلتي ممكن تكون يعني الحاجة اللي أنا مقلقة عليها يعني بالنسبة أنا بوجهها للخبير المكلف أستاذ نصير. أول حاجة بالنسبة للمحكمة الجنائية، إذا هو بوافقني في إنه بطء الإجراءات في المحكمة الجنائية من يعني القضية المختصة يعني انتهاكات دارفور من 2003 ولحد الآن، البطء في الإجراءات وعدم تسليم البشير ومعاونيه للمحكمة الجنائية ممكن يكون هو أثر على حالة الإفلات من العقاب في السودان. فهل حاليا نحن بالنسبة لنا كسودانيين المحكمة الجنائية نحن ممكن تكون هي يعني مكان ثقة بالنسبة لنا يعني لتحقيق العدالة؟ إضافة لكده نحن برضو الإشكالية بتاعت إنه نحن عندنا إشكالية لحد الآن في إنه المؤسسات العدلية في السودان محتاجة إعادة إصلاح كامل حتى إنه نحن نقدر نحقق العدالة. يعني كيف إنه نحن نقدر نوازن بين الاثنين ديل؟ نحن ما قادرين نثق في المؤسسات العدلية في السودان، ولا قادرين بالطريقة اللي اتبعتها المحكمة الجنائية في إنه نحن نأمل حتى لو تم فتح تحقيق حاليا في آخر جريمة بتاعت إبادة جماعية في دارفور في إنه يتم تحقيق العدالة في السودان. الحاجة الثانية، نحن حاليا نفتكر الأولوية بالنسبة لنا حماية المدنيين. ليات مدى ممكن يساهم السيد الخبير المكلف في حماية المدنيين السودانيين؟ الآن عندنا حالات كثيرة بتاعت اختطاف أو اختفاء قسري واعتقال غير مشروع مثلا من قبل قوات الدعم السريع بالنسبة للمدنيين، إضافة لأنه ما يعني عدم استطاعة حتى المحامين في أنهم يقوموا بإجراءات فتح بلاغات بتاعت مفقودين، واضطروا في انهم يعني يتم فتح البلاغات في ولايات تانية. لكن نحن في السودان ما عندنا سيستم اتحادي بيقدر انك انت يعني تقدر تباشر القضايا بشكل عملي يعني. شكرا جزيلا.
أنا اسمي موسى جون من إذاعة صوت المجتمع في كودة، وبرضه تابع لإنترنيوز. الحاجة اللي أنا دار أضيفه أو دار أسأل عنها المشاكل اللي حصلت بتاعت الجرائم اللي تمت في السودان يعني ما حاجة جديدة، وهي طولت، والناس اللي اتأثروا ده المواطن أو الشعب المسكين. يعني الناس يتكلموا كتير عن الولايات اللي عرضت المشاكل اللي هي ولاية بتاعت دارفور، وبرضو عندنا جنوب كردفان، وعندكم برضو النيل الأزرق. في تقارير إنه قاعد تتكتب وبترفع، لكن يعني بتركز كتير لجهة أو لطرف واحد، وبعد ذاك الحاجات بقت ما بتوصل للجهة الممكن هي تقدر، عشان ما الناس تقدر توصل وتلقى المعلومات الحقيقية. الحتة بتاعتي اللي أنا داير أقولها، كيف أن إحنا نقدر نكون عندنا ميكانيزم اللي انتوا بتلقوا الريبورت الحقيقية اللي قاعد يحصل للشعب تحت. لأنه كلامكم انتوا قاعدين تتكلموا ده زي ما في واحد سبقني قبل شوية، انتوا بتتكلموا حاجات دبلوماسية هناك فوق، لكن ما بتعرفوا تحت الناس تعبانين زي شنو. أنا المتكلم معاكم هسه ده أنا واحد من الناس اللي إنه victims لأنه مشيت قاعد نصور للمواطن وانضربت، وما في زول إنه قدر عشان ما إنه يعرف إنه في شنو الحاصل. فالسؤال بتاعي، الطريقة اللي انتوا بترفعوا بيه التقارير دي كيف عشان ما إنه المجرمين دول يتحاسبوا، لأن المواطن يعول حسه هو تعبان. شكرا.
Thank you. So I'm Andrew Songa from Kenya, independent consultant. I just have a brief question for Betty with regards to what you highlighted around the Hilson Habre case and universal jurisdiction bridging the gap on some of the inconsistencies of the ICC. I'm just wonder, how can we augment universal jurisdiction efforts to also bridge the gap on reparations to victims? Because we know also with some of these prosecutions, what lags behind is support to victim groups in a very tangible way by way of reparations. Thanks.
I'm so sorry. I'm so sorry. Yeah, no, I was just saying he will answer the questions now. I was just reminding that we also have an ICC session a bit later, so you don't have to address all these issues now, as you wish. Yeah, please. Are you speaking Arabic or English? English.
No, maybe I'll mix.
Yeah, you mix.
In case, from the beginning, I decided already that all ICC-related question will be left to Her Justice. Some colleagues are a bit, I'm sorry to say, confusing between the role of the UN, this building, this flag, this that you see, which is a secretariat in the hands of states. It is not up to the UN to punish. It is not up to the UN to ensure accountability. It is in the hands of the states, and the UN is a body, is a mechanism, is a forum for states to meet and agree or disagree. Let me remind that since the outbreak of this conflict in Sudan, the Security Council has not even managed to issue a presidential statement, the simplest step they could take, because of the political division inside these bodies. In the Human Rights Council, for example, we have met on 11 May to review the situation in Sudan based on reports submitted by the High Commissioner, but many of you NGOs, by media and by myself. All Arab states were against the expansion of the mandate of the expert to cover the ongoing conflict. Most African states were against because they are always extremely careful in the language they choose, in any role they would give to another body. It's a very difficult and very confusing system, but that's the reality. One of the colleagues has asked on the responsibility to protect. Again, the responsibility to protect is in the hands of the state, the sovereign state in place. Exceptionally, it could be assigned to an external force, an international force, African or international, whatever it is. But it's not the UN. We don't have soldiers. We have people who are serving in other states and put at the disposal of a UN decision to provide protection or ensure peace in some areas. Most of you said it, the atrocities that are being committed and violation committed today are not new. They have been there. And there were many reports in which we shared with the Human Rights Council on these abuses and violations. We met with Mr. Hameti, we met with Mr. Burhan, we met with the Minister of Justice, Minister of Interior, Minister of Foreign Affairs, and we provided them with a list of issues that need to be urgently dealt with. The excessive use of force against civilian protesters, the declaring a zero tolerance policy vis-à-vis any act of sexual violence or violence against women and girls, the review of the emergency legislation in Sudan, which is really a dictatorship. يعني السيد المحافظ أو السيد الوالي يقدر يوضعك في السجن مدة 6 أشهر بتجديد بدون استشارة أي حاكم أو أي قانون. هذا حرام. This is not possible. This is not acceptable in a civilized world. Therefore, they have promised to review the legislation on emergency, to review to declare the zero tolerance policy, to release all prisoners that were abducted during civilian or protests, and to stop the excessive use of force. Nothing, very little, only very little progress has been achieved in this relation. What we do with our reports and testimonies, we submit that to the Human Rights Council, which is the body to decide on where to refer the case, what to declare, how to accuse or not to accuse. Let me draw your attention to a fact. No state whatsoever has pointed to a particular of the two belligerents in Sudan for having committed crime. The only one who said that was the High Commissioner Volker Turk during the meeting of the Council on 19 June, where he clearly, I did the same for some specific cases, pointing to a specific party to this conflict for having committed this and this crime. No other state. The states always refer to the parties to the conflict, to the warring parties, without any distinction. And that is quite important. I was not able to hear all the questions, but at this stage, and we will have other opportunity to interact, and we will certainly try to answer all your questions and your concerns. Thank you.
So before I turn to the one question that was directed at me, I just want to say that in answer to the questions and frustrations expressed about the ICC, I think over the last, maybe 15 years, a consensus has emerged that strengthening our national criminal justice systems is the answer, is what is going to get us justice, is what is going to ensure that we are addressing the impunity for all of these crimes that are being committed in our own lands. And so I think treating the ICC as the elixir or the one institution that is going to fix our problems is probably a little misguided, because it is not possible. There are just too many crimes that are being committed on mass scale that it would be impossible for that one court to be able to address all of it. I think strengthening the complementarity regimes becomes really important, and strengthening our own domestic systems. And I think we'll have a chance to speak to some of this much later on. Obviously, the question that was raised earlier about the attention span of the international community as pertains to international justice problems, and how the geopolitics determines who is getting what attention at which institutions, is something also that we have considered. Now, turning to Andrew, and your question around universal jurisdictions and reparations to victims for these crimes. I think we know that, under the transitional justice regimes and all of these peace agreements that are being concluded, there is always that, obviously, that provision around reparations. But it is where most states and most donor, institutions draw the line. They will do everything else. They will attend to, accountability for the crimes. But when it comes to reparations, which is a state responsibility, then it becomes very, very problematic. And it is often actually not to the benefit of the victims. Now, of course, when we talk about reparations, we are thinking more than just compensation. We are thinking about restitution. We are thinking about the most important, which is guarantees of non-repetition. That you want the situation that enabled the commission of atrocity crimes to happen to be completely removed. And this, of course, requires a lot of work over a long period of time. It is about ensuring that you're having structural changes to your laws, to your institutions, but it is also about making sure that you have sufficient stability and a reparations framework that can be implemented in country, not externally. Because if we are going to rely on donor states to facilitate our reparations regimes, they are going to come and build schools and build hospitals and build roads, which is all very well, but that doesn't repair the victim, the individual victim of the atrocity. Now, I think we have good examples to draw from the African continent. Sierra Leone is one, Liberia is another, Rwanda is another, where they implemented reparations regimes that I think address not just their structural legal problems that they had. And here we haven't even spoken about women and the gender question, and even highlighted what that reparations would look to the woman, because a woman who has been sexually violated, who has suffered multiple rapes, is not going to be repaired by money. They are not going to be repaired by any type of restitution. You cannot restitute that kind of a crime. Women don't want to go back to the situation they were in, that facilitated the commission of those types of crimes. We see here in Kenya, let me give an example of my own country, so I'm not picking on anybody. Every time we have a civil unrest, all of a sudden the rape cases go up. This is because rape is happening, even under normal circumstances. And so, some of the civil society groups here actually decided to go to court and get declarations from the High Court that the state has a duty to protect its own citizens. And the court actually issued that order and issued declaration asking the government of Kenya to pay certain victims who had gone to court because they had been raped during the 2007-2008 problems that we had. And judgments were issued against the Kenya government because they failed to protect their own citizens. This is now an example of a national system working properly. And I think this is where we can make that connection in terms of universal jurisdiction and reparations. I'm actually not sure how it would work, but it could certainly be something that could be included in terms of ordering individual orders for reparations against an accused person. Because when you bring a case of universal jurisdiction, you're bringing it on the basis of individual criminal responsibility, not on the basis of bringing a whole sort of entity like the army or people like those, or an institution to face trial. So, but in terms of domestically, I think this is something that can be done within the states that are implicated. I think the other issues on the ICC, we can address them in the subsequent sessions. Thank you.
Thank you, Betty.
Thank you very much. And I want to close the session, we are 10 minutes late. Radhouane will be with us today. He will also be with us tomorrow. So there will be opportunities to ask more questions. And, I think you will be happy to answer more questions. Yes, so please approach him personally. And Betty will have to run now, but she will also be back with us. So there will be more opportunities to ask questions. Let's give them an applause and thank you for the panel.